Okay, good afternoon, everybody. Welcome to the afternoon session of Navigating the U.S. Visa Landscape. My name is Jennifer Clinton. I'm going to be the moderator this afternoon of a very distinguished set of panelists who have a tremendous amount of expertise in helping individuals and businesses navigate the U.S. visa landscape. So today's discussion is meant to be a very practical conversation that's going to focus on a number of visa categories and processes that are really focused on investors, people interested in investing in the U.S. or starting a business in the U.S. And as you probably are very aware, there's dozens of visa categories, immigrant and non-immigrant categories, but we are narrowing the conversation today to really focus on what we see as relevant to this particular audience. And on the screen to my right here, you can see the list of non-immigrant visas that we're going to be covering. On the left-hand side, the business visitors, B1, the E, treaty trader investors, the L and the O, as well as EB5. And again, we're not here to cover the entire landscape of the U.S. visa process, but focused on what we think can be relevant to you. So by way of introductions, I'd like to kind of start off and introduce our distinguished panelists today. By way of introduction, as I mentioned, my name is Jennifer Clinton. I'm the president and CEO of a nonprofit organization based here in Washington called Cultural Vistas. We help businesses bring skilled professionals and top student talent from around the world to the United States to complete internships, training programs, and a variety of short-term assignments. Every year, more than 1,000 businesses work with us, from Fortune 100 companies to small, medium-sized enterprises to provide the J1 visa that we won't spend much time on today, but that's just by way of introduction. To my right, we have Ruslan Bocancea, who is from Romania and is an American immigration attorney and founder of Bocancea Law Group. And I'm going to let Ruslan tell us a little bit about himself.
Okay, thank you. So it works. So I practice business immigration law. That's all I do. I work with people and companies interested in doing business in the U.S. And I've been doing this for about 10 years now. I went to school in South Dakota. It's a state in the U.S. and Minnesota as well. And I graduated from law school in Minnesota. Then after law school, I started my own practice. And while I maintain a business presence in the U.S., I spend most of my time in Eastern Europe. I have an office in Bucharest, Romania as well. So, and I'm happy to share my thoughts on U.S. visas here.
Wonderful. And to Ruslan's right, we have Linda Rahal, who's the managing shareholder at Trow and Rahal based in Washington, D.C.
My name again is Linda Rahal, and I am the managing shareholder of Trow and Rahal. We were founded in 1993. We've been in business for 26 years, located just outside the nation's capital in Bethesda, Maryland. We too focus on business immigration with an emphasis on entrepreneurs and investors. Our firm is also a member of the International Network of Boutique Law Firms, INBLF. There's a brochure in the back. INBLF is a group of boutique law firms in the United States that can assist entrepreneurs and companies wanting to come and develop in the United States. And I also have an insert on visas in that. The brochure is also available in Spanish and Portuguese. And the URL is on the back of the brochure, so feel free to pick that up on your way out.
Thanks, Linda. And to Linda's right, we have John Meyer, who is a partner of Foster Global based in Houston, Texas. You want to share a little bit about yourself, John?
Thanks, Jennifer. My name is John Meyer, based in Houston. Foster has been around for approximately 45 years. We focus on global immigration, and so I practice U.S. immigration, but I have other colleagues who focus on visas for folks leaving the United States going to other countries. We have offices in China, Vietnam, Malaysia. We have a person working with us in London, and we'll be opening an office in Germany this year. We also have offices in Mexico City, and we have a back office operation in Central America and El Salvador. My practice is primarily with investors. We have a team of people I supervise handling non-immigrant investors, as well as a team of folks handling EB-5 process for immigrant investors. So look forward to sharing some thoughts with you guys today. Oh, and we also have some handouts in the back. Feel free to take one of those too.
Wonderful, thank you. So we're going to kick off the discussion with Ruslan to my right here, who is going to give us a little bit of an overview of what you're seeing on this board here, and then hone in on the B1 and B2 visa categories, as well as the E investor visa categories. So, Ruslan.
Thank you very much. So just a quick note to let you know that there are so many other visa categories available to foreign nationals, but we just don't have time. We're dealing with the most complex immigration system in the world. So we picked the most relevant for you today, and we'll discuss each one, and we'll be open to we'll have time for questions at the end, right? So as you can see on that PowerPoint, when people come to U.S., they either come as non-immigrants or they come as immigrants. They come on a temporary visa or with an immigrant visa or with a green card. I'm going to cover the B1 and the E1 and E2 visas, which are temporary visas. And then we'll talk about L1s, O1s, and then about the immigrant visas as well. I'll start with the B visa. Probably most of you have a B visa where you've experienced the process of applying for a B visa. It's a temporary visa designed for doing the preliminary steps toward investing in the U.S. So let's say you want to come to U.S. for business meetings, for a conference like this one, the most appropriate visa would be the B1 visa. It's easy to get. It's just filling out an application. You pay the visa fee, and you can get the visitor visa in about probably 5 to 7 days, depending on the embassy that you're applying. It's a great option for the preliminary steps, and that's what we tell our investors. This is the first. It's kind of the baby step visa where you come in for business meetings, you establish a business presence. Obviously, the cons of this visa is you can't do much on it. You can't work in the U.S. You cannot generally get paid on this visa, so you would need a different type of visa. Also, you must maintain your home ties back home, and then you can also have issues at the customs if you enter too many times on a visitor visa. You have to be careful that way. We have many clients who've been traveling on visitor visas for a while, and then once in a while, the customs will mention that they're probably abusing it if they're entering too often, and that we need a different type of visa. Which brings me to the E1 and E2 visa. These are my favorite visas. That's what I do. 80% of my practice is E1s and E2 visas. They're investor visas. Again, this is a temporary visa. It's not the green card, not the EB-5 that John will discuss, and we'll get into details. The E visas were created with the idea of encouraging foreign investors to invest in the U.S. I love it, and one huge advantage with the E visa versus other visas, or E1 or E2, is that you can apply for this visa at the embassy. You don't have to deal with the immigrations in the U.S., the Department of Homeland Security. So I love this. I have a good working relationship with embassies, and I enjoy talking with a human being, which we don't always have the luxury when we do an EB-5 or a green card. So I love this, that I have a conversation with someone, that I can talk about E-visas. Some of the requirements, so the E-visa was engaged, so the E1 was designed for foreign investors interested in engaging in substantial trade with the U.S. The E2 was designed to be used for foreign investors interested in investing a certain amount of money in the U.S. To do business. Some of the requirements is one thing that I need to mention is that not all countries belong to a treaty. There is no treaty with every country, the E2 between the U.S. So you need to check and look into this. And you can find this on the website. It's public information on the Department of State. So, but if it is available, it's a great option. For example, Chinese nationals cannot apply for an E2. And I just got back from a conference in China where we were discussing options for Chinese nationals outside other than EB-5, which John will discuss. Mm-hmm. And one of the things that was discussed there, we had the Consul General for Grenada, who was selling the idea to Chinese to become a citizen of Grenada, to invest in Grenada, get the passport, and then apply for this E2 visa. So they would be eligible for this. Brazilians, for example, are not eligible. So for Brazilian clients, some of them are eligible to become Italian citizens. They can get their citizenship through their grandparents, so then they can apply as Italian citizens. So you have to check on the treaty, see if that's available. And if it's not, you have to look into some other options as well. And I'm privileged, most Eastern European countries belong to this E1 or E2 treaty, and that works out well. On the E2 side, other than the country being part of the treaty, the activities, including the activities that are considered trade, that you need to keep in mind are the international banking, insurance, transportation, tourism, or communications. But another requirement is that trade has to be principally between the United States and the country of origin. And you have to have the desire or the intent to return home when the visa status terminates. On the E2, as far as requirements, again, we need to make sure that we belong to the treaty. Another requirement is that the investment has to be substantial. And the nice thing about the E2 is that Congress didn't give us a minimum amount as to how much we can invest. And many people come and ask, how much should I invest? I've heard that you need to invest $50,000 or $100,000 or $1 million. The good news is that Congress has not defined this a specific amount. So it allows the U.S. embassies or the consular officers to determine the exact amount. It's a great visa. Again, the E1 and E2, and some of the advantages of the E-visas are that they're easy to obtain. I would say on average, our clients get E2 visas in about 2-3 months. Depending on the embassy. Again, it's not very difficult. And again, you make this application with the embassy. One of my favorite advantages of the E2 visa is that dependents, like the spouses and children, get dependent visas. So, for example, the spouse of an E2 is able to come to U.S. to work and study, and the children under 21 can study in the U.S. on the E2 visa. So this is great, and we're talking about 2-3 months for a family to be able to move to U.S., to put their kids in school, for the spouses to work if they want to work. They get social security numbers as well because E-visa permits work, allows work. Another great advantage is that in theory you could live in the U.S. with an E2 visa for the rest of your life. As long as the business is running and you can prove that the business is operating and running, you could just renew it every 2 years or 5 years, depending. Some embassies will issue an E2 for 3 months, like Ukraine, for example, or Moldova. And Romania, for example, can issue an E2 visa for up to 5 years, which is renewable, and you can renew it every year. Again, another advantage is that the investment, it has to be substantial, but there's no specific amount. And a good immigration lawyer usually makes a difference because the lawyer has experience with a specific embassy and knows from his or her experience about that particular embassy's practice. The investment can be in cash, can be equipment, inventory, or intellectual property. So it doesn't have to be, you don't have to come up with $50,000 or $100,000 or $150,000 in cash. You could do a combination of those. And we had a client who didn't have much cash but had intellectual property, invented a platform designing applications. So we used that platform, we gave it a value. It was $100,000, so then we argued that the investment was good, was substantial for that particular case. And other things that, the source of funds, it does not have to be from the U.S., it could be from anywhere. It does not have to be from outside the U.S., it could be from the U.S. as well, the funds. So we have clients who don't have money, but they come to U.S. on a visitor visa to seek funds for their investment. So it could come from the U.S., it could come in form of a loan, it could come in form of a donation, or from other sources that you have.
A gift.
I'm sorry?
A gift.
Yeah, we're a gift, yeah. So we've had one case where they said they found 10,000 euro under a mattress. Mm-hmm. And they said, can I use that? I'm like, well, as long as it's, who am I to say that your grandma? And it was interesting that the grandma left 10,000 euros a long time ago. And I didn't think euros were in existence at the time. I'm like, so anyway, So it's fine.
How
if you-
convenient.
Yeah, it's fine if you have if you find 10, which is great. If you find 10,000 euro under a mattress, it can be used as long as it's documented. As long as you go to your fiscal authorities, declare it, say, hey, I found 10,000 euros under the mattress. That works. It worked in that case. So
Wow.
so we made them register the amount, and they went to a notary public. They declared that amount. They paid taxes on it, and worked just fine. So it's clean money. Who am I to say that grandma doesn't leave things, under the mattress? But and then in terms of case studies, we've done beauty salons. So anything you can think of. So it can be a beauty salon, restaurant, gas station, embroidery. We had a DJ in Minnesota. I helped an Italian national move to Minnesota. He wanted to become a DJ. Well, if you want to be a DJ, who am I to say that you don't deserve to get an E2 visa and move there? Transportation, B&Bs, eyelash extension salon, anything you can think of. And you can start a business from scratch. You can also buy an existing business in the U.S. You can do a franchise, and you're eligible for the E2. A few statistics quick, and I'll let you, Linda, to go on with the other visas. For fiscal year 2018, and this is public information, UK, Department of State publishes the number of visas issued by embassies. So, for example, the UK national last year received 2,740 E2 visas. Just to give you an idea, Germany 3,800, Spain 1,300, Japan 13,000, South Korea 2,300, Argentina 484, Brazil 351. But again, these Brazilians probably had another nationality because they're not eligible for the E. Total for Europe, I have 16,567 E2s last year, 2018. Total for Asia, 17,328. Total for Latin America, 1,740. E1, grand total worldwide, we're looking at 6,542. And worldwide for E2s, 41,181. So just to give you a general idea, and many people don't know this visa exists, but now you'll know and you can do a little bit of research. And the last thing that I want to mention I'm done is actually I came across this little statement on my way to from Romania to US. It came from Exit Planning Institute, and they had this little commercial talking about baby boomers, and it said, and I'll just read it straight from, I did a copy and paste. Baby boomers, are you wanting to retire in the next 10 years? The market cycle, the number of businesses for sale, and the lack of capital available may work against you. If every baby boomer wants to sell, over $10 trillion of capital is necessary. So $10 trillion, and the equity available to complete these transactions is roughly $535 billion. So it's a great statistics, and it just reminded me that there's so many opportunities for foreign investors, and E2 is will remain one of my favorites, and I'll use it as a vehicle for my clients to come to US. And with that, I'll
Wonderful.
let you, Linda.
Thank you, Ruslan. Linda, we're going to turn it over to you to talk about the L1 and O1 visa categories.
So what do you do when you can't do an E2 or an E1 because you're not a member of a treaty with the United States? You have to look to other alternatives. And the one that we look to most often is the L1 intracompany transfer, which can be for any multinational transfer, but it can also be used to start up a new office. If I have the opportunity, I will do an E2 over a new office L1. But if I don't have a E2 treaty, I will resort to the new office L1. And I want to use an example of a recent client of ours to show you how it works. We had an investment firm come to us from the UK. The UK is a treaty company. They can do E2s. And so we did E2s to get one or two of the people over here. But they also had a German national that they wanted to bring over. But you can't get an E2 for a German national for a UK company, because for the E2, both the company and the foreign national need to hold the same nationality. So we had to do a new office L1 for the German national. And what does a L1 require? It requires that the person has worked for the company outside of the United States for at least 1 full year. It requires that the person worked in either a managerial, executive, or specialized knowledge position. And it requires that the company outside the US and the company inside the US are more than 50% commonly owned. So what happened is with the E2, they set up a new business in the United States that was a subsidiary of the UK business, and we were able to file an L1 petition with the U.S. Immigration Service. The L1 petition gets filed with USCIS, U.S. Citizenship and Immigration Services, instead of the U.S. Embassy. So the USCIS adjudicates that petition. If you file with what they call premium processing, an extra filing fee of $1,410, you get the L1 petition adjudicated in 15 days. Typically for a new office L1, the USCIS is issuing a request for evidence. No matter how well you document the initial petition, I would say 90% of them are getting requests for evidence, and you respond to that request for evidence, and then you get the L1 approval notice. I've never had one where we didn't get the L1 approval notice for a new office L1. We always get it, but you have to submit a lot of documentation, including a business plan that shows that you're going to hire U.S. nationals, what your stream of revenue is going to be. So for both E1s and L1 new offices, they like to see the office already set up. They want to see a lease. They want to see that you have clients. They want to see that you have the intent to hire employees or already have hired 1 or 2 employees in the United States. So with this investment firm, they opened a new office in New York. They wanted to ramp up very quickly. They invested close to $1 million to get this office running. They quickly hired 5 to 10 people in the United States. So it was a good new office L1. And so that was eventually approved by U.S. Immigration, and then the German national went to the U.S. consulate in Frankfurt, applied for the visa in Frankfurt, obtained an approval of the visa, and was able to come to the U.S. So the issue with the new office L1 is that the initial visa is only granted for 1 year. The U.S. Immigration Service only approves it for 1 year. And then you have to file an extension at the end of that year. And you have to start preparing to file that extension months before you actually file it. And to get the extension approved, you actually have to show that you've done most of the things in your business plan, that you've hired U.S. employees, that you have revenue, and really these days they're requiring to see that you actually have a profit. And that's a really difficult thing to do in less than 1 year in starting up a new company. So this company that we did it for, the investment firm, you know, with $1 million investment, with the intention in their business plan to hire 40 people in the United States, I was pretty confident that we'd be able to get the L1 extension. We just got the person here, so we'll see in 6 or 8 months if they do all of the things that they want to do. But with that case, I felt that an L1 new office would be good and we'd be able to get the extension. Because the last thing you want to do is get here for the first year and then not succeed on the extension because you haven't hired enough people, you don't have enough business. And you know, ramping up that quickly in the United States can be difficult. So in my second example, I want to talk about how if you're forced to do an L1, how we might avoid that new office L1. And so we had another client from the Dominican Republic, again, not in the DR is not a treaty country. They don't have the E2 available for him. He owned a concrete and remodeling type business in the DR with about 20 employees, decent revenue, and he wanted to open an office in the United States and bring his family here. After discussions with him, the ability to ramp up that business and get federal contracts and enough revenue to get the extension was going to prove difficult. So we talked and discussed, and eventually this is what he ended up doing. He ended up purchasing an existing company in the United States. By doing that and purchasing the existing company, he was able to get not a new office L1, but a regular L1. The regular L1 is issued for 3 years, and the L1 can be up to 5 years or 7 years with extensions in 2-year increments. So we avoided having to do that new office L1 by purchasing a company in the United States. We have been successful on getting extensions of new office L1s, but it is a difficult process. And once we actually, the company hadn't ramped up, but there were circumstances. Shipments didn't come in from Egypt quickly enough and things like that. And we actually were able to file a second, not an extension for 2 years, but got a second initial 1 year for them to ramp up that new office L1 to the point where they could then get an extension in 2-year increments. The benefit, so that's a non-immigrant visa, the L1, for intra-company managers, executives, or people with specialized knowledge. That's L1A for managers and executives, and L1B for people with specialized knowledge. The advantage of coming in on an L1A for a manager or an executive is that it lines up nicely to getting a green card if that's your goal. Because there is a corresponding green card immigrant visa category for multinational managers and executives. And it has the same exact requirements as the L1, except it does require that the business in the United States has been in business more than 1 year. So if you get the new office L1 for only 1 year, you need to get the extension. And then once your company in the US has been doing business for more than 1 year, and it's big enough to sustain a green card application, you can then file for a multinational manager green card if that is your goal to get in the United States. The L1 also allows the spouse to get work authorization in the United States, which is a good advantage to both the E and the L visas. The second non-immigrant visa that I was going to talk about, if the E is not available to you, is the O1. The O1 is a visa for persons of extraordinary ability in their field. It can be used to open up companies in the US, but more often than not, you're going to want to have an existing company in the United States. But the O1 requires that you be a person of sustained acclaim, either national or internationally, and that you're one of the few people who have risen to the top of your field. And that sounds kind of like a daunting standard to meet. But it can be done if you think about it. If you have a company in your home country, and you are the largest, and you're the CEO and owner of that company, and you are the largest supplier of X or Y or a product in your company, and everybody knows your company, then you have national acclaim. And that national acclaim can translate to an O1 visa where you come in. You don't have to have international acclaim. So to show national or international acclaim, they make you show that you meet at least 3 of 10 criteria. What is that criteria? That criteria is that you've won national or international awards, that you have publications about yourself or about the work that you've done, that you've been the judge of on a panel of other people's work. Help me with these 10.
High remuneration, the salary, the payment.
Yeah, that
Member of association, high remuneration, so high salaries,
and
member of associations
you've worked
requiring.
for organizations that that have
Distinguished
reputation. So there's a list of 10 of them, and you have to meet at least 3 of them. But meeting 3 of them by itself doesn't get you the O1. You also have to show the sustained acclaim, either national or international. If, again, the O1 petition is filed with the U.S. Immigration Service. So the U.S. Immigration Service adjudicates it once it's approved. Again, there's a high rate of RFEs, not as high as the new office L1. In fact, we don't get many RFEs on O1s, but I hear they have a rather high rate of requests for evidence. But once you get the approval from the U.S. Immigration Service, then you go to the U.S. consulate in your home country and apply for the visa. The visa is the stamp you get in your passport that lets you get on a plane and come to the United States. When you get to U.S. the Customs, CBP, at the airport, I always say, you then knock on the door and say, I have an O1 visa and an O1 approval notice, and then they let you in O1 status. The O1 status can be granted initially for 3 years with 1-year increments, unless you can show a new venture, and then you can get another 3-year O1. The disadvantage of the O1 is the spouse does not get work authorization, but the spouse and children come in the derivative O3 status.
Yep.
Also the advantage of the O visa is it also lines up nicely for a green card. There is a like the L1 that has the corresponding green card category of multinational manager and executive. The O1 has a corresponding green card category for persons of extraordinary ability. The criteria is exactly the same as the O1. However, they do place a much higher standard on it because immigration feels like they're conferring a greater benefit, the green card, the permanent resident status in the United States. So sometimes people can get an O1, but they're not quite at the level of a extraordinary ability green card. So we will tell them to stay on the O1 for a while, build up your international acclaim while you're in the United States, get recognition, get awards, do a little PR on yourself, get publications in newspapers or magazines, trade journals, and then you can try for the extraordinary ability green card. So those are the kind of paths that you can come in as an entrepreneur and investor. I still do the E if I can do the E. If not, I will look to other alternatives. Other alternatives to get you here are the L or the O, and then they have paths to green card. But the E does not have a direct path to green card.
No.
And that's where we're going to let John speak about the EB5 investor green card.
Great, thank you. John.
Okay, thanks. I'm starting my timer now. So I want to start out by saying how much I appreciate Ruslan and Linda and their analysis, because I think our jobs, I think we all would agree this, is developing a strategy for the clients, right? I mean, I've been doing this for 27 years, and I think what we really bring as immigration lawyers to the clients are developing a strategy based on your individual circumstances. And so it's really kind of a custom-made suit. It's not something you can, go to Walmart and buy off the rack. And on occasion, I'll hear folks that say, well, you don't need to have an immigration attorney. And I agree with you. You don't need to have an immigration attorney, but I recommend you get an immigration attorney based on our level of experience, because if you go through one of these processes and you fail, it could be something that might prevent you from coming to the United States in the future and could have a long-term effect on your kind of immigration record and really create some problems. And so, whether it's us, whether it's somebody else, look for board-certified immigration attorneys, people with lots of experience who can really give you a full consultation in identifying the non-immigrant visa as well as the immigrant visa options in your particular case. So that was 2 minutes of the, a minute and a half of that. Talk to an attorney. I think it's well worth your time. So my topic is covering the EB5 immigrant process. EB5 is not a visa. It's not like a B1 stamp or an E1, E2, L1, O1 stamp that goes in your passport. It's a process to be able to immigrate. And EB5 really means it's the fifth category of all the other immigrant categories: EB1, EB2, EB3, EB4, EB5. And so a lot of people will say it's a visa, it's not a visa, it's a process. So what is this process about? It's about making an investment in the United States. In 1990, Congress passed, and actually my partner Charles Foster was working with President Bush at the time, helping him look into this. Process is that if you come from abroad and you have a legal source of funds, you come to the United States, you invest that money, and you create employment. The limit is they want you to create at least 10 new U.S. jobs. And if you do that, the United States is going to give you your green card. It's going to be a conditional green card at first that's going to last for 2 years, and then you're going to have to remove those conditions by showing that you actually created the employment, and then you get your permanent green card. There's kind of two ways of going at the EB5 process. One is a direct investor. A direct investor is a person who's going to come set up their own company and create direct jobs, actual jobs. And while that may be very interesting to a lot of people, approximately only 2% of the total cases are direct cases, okay? And I would say, and Lynn and I were chatting about this earlier, is I think the approval rate of direct cases is relatively low compared to the other way of immigrating through EB-5, which is regional center process. So, but the direct process in general requires that you have a new commercial entity that you're investing in. So that's an entity that was created after 1990. The idea is that you're going to come in and spend money on setting up your business, developing your business, starting your business, and you as the investor are the one going ahead and doing that. So we see people do restaurants, obviously labor-intensive type businesses because you've got to create at least 10 new U.S. jobs. So it better be a business that you're going to be actually creating employment as opposed to just a service company that may not create a whole lot of employment for you. Okay? I think the other issue here is really the direct jobs. I've seen in my career people who set up, for instance, a car wash. Okay, lots of employees. The problem is, and I live in Houston, Texas. Some of his employees, he didn't realize weren't legally eligible to work in the United States. They had presented documents to show that they were, but they weren't. So at the time he went to show that he had created the jobs, unfortunately, he had not created 10 U.S. jobs. He had created 7 U.S. jobs with 3 folks who were not eligible to work in the United States. That created a pretty substantial problem for this person, and they eventually ended up immigrating in a different way. So direct investment, if you want to do your own business, I get that. It's going to be a harder path. I think there are better paths for you, whether you come in on an E1 or an E2 or an L1, there are other paths to look at. And then again, that's where working with an experienced attorney, you can go ahead and come up with a strategy. The regional center process started in the early 90s, 92, I believe. And that's a process where you're investing into a project where they're pooling investment. So the idea is that a regional center, which is a U.S. company that's been approved by the Immigration Service to pool money together, and at the end of that process, enable people to get their permanent residence. Right now, there's probably more than 1,000 regional centers in the United States. So as a result, you have to be very, very careful on what it is you're looking for if you're going to make a regional center investment. I think the advantage of the regional center investment as opposed to the direct investment really supposes that you're going to come to the United States and you're going to go ahead and supervise and run that business. Whereas the regional center investment is a lot more passive. You're going to be a limited partner in a project, and looking at my time, 6 minutes, and based on that, you don't have the need to actually come immediately to the United States. You don't have the need to participate in that business. And usually what I talk to my clients about is continue doing the business that's generating the most wealth for you. And that may be doing your business back in your home country, focusing on generating more wealth than really focusing on coming to the United States and trying to generate a business that may or may not be successful. Okay? The advantage with regional centers is they get to go ahead and count indirect employment, meaning that they have an economic study that basically says if you spend this amount of money in this particular project, many of those projects are real estate development, by spending the money in building the building, for instance, that creates indirect jobs. And there's usually approximately 10 jobs per $1 million spent, okay? So that gives you guys an opportunity to get the benefit of a larger project to help generate the 10 U.S. jobs that are going to be linked to your investment. A couple other things that I want to go back and just double check. So the investment amount is $1 million, but if you invest in a targeted employment area, the investment can be as low as about $500,000. So whether it's a direct investment in either a rural or high unemployment area, which why would you put a business in a rural or high unemployment area? It's going to make it more difficult for it to succeed, or a regional center where many regional centers have projects in high unemployment areas, lots of downtown communities in many of the U.S. cities based on different geographical zones. Help me.
Unemployment.
Yeah, unemployment, but census tract connecting up to 7 census tracts, they can show that there's a high unemployment where their project is being done.
I think LA at some point.
Well, so downtown LA, Manhattan, and New York.
Well, Washington, D.C., the
D.C.
wharf, the new section of D.C. that was built was done with a lot of EB5 money.
Excellent. And so, but that's a big benefit, I think, for you guys as potential investors. Why? They're bigger projects. The percentage of EB5 money in a lot of these cases are relatively small. And I'll tell you, I think there's another more important thing to consider, is that if you come from a country that is not China, Vietnam, or India right now, and you invest in one of these projects, your cases are going to go very quickly through this process, whereas, unfortunately, the program has been so successful in China, there's what studies tell us, around 16-year backlog. There's a backlog of more than 7 years for Vietnam, and the backlog for Indian nationals is around 5 or 6 years. Why is there a backlog? Because there's only 10,000 visas available per year, 10,000 slots that include the investor, their spouse, and their children, okay? So, and each individual country gets only 7% of the 10,000, 700. So right now, if you were to multiply 700 times 16, that's the waiting line that people are waiting in China. And if you do the math on the other countries, you can see how many people are expected to be waiting before they're able to go ahead and come in. I think the good news is there are some potential changes. It's good news and bad news. There's some potential changes in the EB5 program that may be happening by the end of this fiscal year. There's a possibility that the good news is that they'll change how they count those numbers. Instead of counting the dependent spouse and children, they may count only the investors. If they count only the investors, that's going to help out the folks from China, India, and Vietnam, and probably won't hurt everybody else. One of the downsides might be is that they're going to raise the amount of the investment. The $500,000 investment's been around since 1992. I'm no economist, but I think if just the rate of inflation on that $500,000 is probably worth a lot more today than just $500,000. And so that's one of the justifications to go ahead and raise the amount. The amount I've heard could go up to $800,000. It could go up to $1.3 million. It's going to go up, and it'll definitely go up sooner rather than later. Okay? I'm already over my 10 minutes. I'm sorry. But I would encourage you all, if you have any questions, I'll be available the next couple of days. I'm sure Linda and Ruslan are going to be around as well. And we'd love to answer any questions you might have. So thank you very much.
Great. Thank you all. I have 2 quick questions for the panel, and you can choose which one to respond to, and then we'll open it up to the audience because I'm sure you have a lot of questions. So the first one is, can you talk a little bit about how to practically get started? So, you know, I'm somebody that wants to start a business or make an investment in the U.S. How do you engage a firm like yours, and what can one expect in having conversations with you? The second question is if you can touch on some of the trends that we're seeing now over the last couple of years. It's a little bit of a different environment from an immigration standpoint, and if you could give some practical tips on to the audience of how to navigate some of those trends. I'll start with you, Ruslan.
I can start the first one. So generally, I do an initial consultation with every client, and we come up with a strategy. You know, we go over all the visa categories, and we pick the most relevant ones, and we talk advantages, disadvantages, depending on each case that we're talking about. So in most of the cases, I'll recommend a visitor visa if they don't have one. And I'll recommend taking a quick trip to U.S. because we have clients, I've had prospective clients who came to me and said, I have $1 million, I'm ready, I've read everything about EB5s, I just want an EB5. And I asked them, have you been to U.S. before? No, I haven't, but I'm pretty sure I like Miami and I'm going there. And so it doesn't look good. So first, it's not, I would recommend that they go to U.S. It also looks more credible with the embassy at one point, because if they go to the embassy, whatever visa they pick, if they've been to U.S. before, they look more credible. You know, whether that's an E visa, an OL, or when we get to the EB5 process. But I usually recommend a visitor visa. If they don't have one, we'll help them apply for a visitor visa. And then we'll look into the long term. If they want an E2 visa, maybe during the first interaction with the embassy, I'll have them mention, look, this is my long-term plan. I'm applying for a visitor visa, but I'm a prospective investor. I will be back applying for an E-visa at one point. I'll be back applying for an O visa or an L visa. No surprises there. It's not illegal. So then the consulate is on the same page. They take notes, the consular officer, and then those notes are available for the Customs and Border Protection. So you're honest from day one. You go with a visitor visa, and that's your first opportunity to interact with the U.S. Embassy. Let them know about your short-term plan. Short or long term? Yeah, go ahead.
I was going to add, I mean, the B1 also allows you to set up a business in the United States. You can negotiate the purchase of a business. You can meet with your lawyer. You can meet with your accountant or financial advisor or a corporate attorney. There's a lot of things you can do on a visitor visa, B1 visa, that allows you to really investigate the market. And what I do, I think is the same as you guys, is basically suggest people, you need to do a lot of investigation and research on the front end before you go ahead and plow a bunch of money into the United States. Because what is the business that you're going to do? How much do you know about that business that you're planning on starting in the United States? I recommend people try to work with something that they've been working with abroad. You don't want to start something brand new. In Houston, for instance, there's a community north of town where a lot of folks from Mexico reside. It's a beautiful place. I love Mexico. Don't take this wrong. But everybody in Mexico who loves tacos says, well, I know how to make tacos. Not true, okay? This one restaurant's gone through like 5 different hands in the last 6 years because everybody thinks they know how to make better tacos. No, it's hard to run a restaurant, okay? It's not easy to manage, all of the things that go on in a restaurant, all right? So if you're coming to the United States and you think you're going to go ahead and put in a restaurant, there's a lot of qualities that people need to have to manage a restaurant.
The other thing is when you come here, you need more than just an immigration lawyer if you're going to set up a business. You need somebody who's going to help you with the corporate work, maybe international intellectual property if you need a patent or a copyright in the United States. And as I said before, I belong to the international network of boutique law firms where we can refer you to people. But I'm sure John and Ruslan have their own network of people that can help us so that we don't do the corporate work, but we know people who do, and we will work with them to make sure that it's set up properly. And also, as they say, you can come in on a B1. When I spoke about the L1, it's the same for the E2. They want to see that the company is set up. They want to see that you have office space. They want to see that you have customers. All of that you can do on the B1 visa. And as a potential prospective investor in the United States, they want to see the money in your bank account already, and they want to see most of it spent already before they're going to give you the E2 visa or the new office L1. So I've had people come in and out on a B1 for up to a year before they actually make the application for the E2 or the new office L1. And I'll trans into the next question on the trends, and then I'll let them pick up again. The trends is everything is taking longer and everything is more difficult in immigration these days. So your planning has to start well in advance. I used to say 6 months for a new office L1. I say up to a year now. You need to be talking with an immigration lawyer before you form the company, before you do anything. It should be often we're the last person they come to. Oh yeah, I need a visa. We should be the first people, and then we can help you and facilitate getting all the other people that you need. But it's a process. A lot of documentation that is needed. Extensive business plans, records of where you got the money, usually not under the mattress, but hey, you need to document a lot of things to immigration or the U.S. consulate. So everything takes much longer. In London, I just did an E2 in London, and there is a 57-day wait to get the visa appointment for an E2. So that's just 2 months once we submit the application to the U.S. Embassy, because for E2 visas, unlike L1s, you submit at the U.S. Embassy, and they usually review it before they call you in for an interview. So that can take 2 or 3 months in some locations. It can take 2 or 3 weeks in other locations. So that's on trends.
I agree, yeah.
Yeah, trends. I mean, I think totally agree with Linda. Things are more difficult. I guess I want to also echo that, and I throw this out there as a little bit off topic, but a lot of times people will come to the United States and buy a house. you can absolutely come and buy the house. If you have the money, you want to buy a house. But sometimes people will get confused that by buying a house, they can put their children in public school. You cannot do that.
No.
Absolutely cannot do that. And I was just thinking of some of the errors that are very common, and that's one of them. People, pretty much across the United States, I mean, the idea is that children should go to school no matter where they're from, no matter what their legal status is. But it is a grave error to make to put your kids in public school when you're here on a visitor visa.
That's one, and then the other thing is we had a specific client from France. He was a retired doctor, and he had issues at the customs entering on a visitor. He was entering under ESTA, which is the equivalent to a visitor visa, and he was arguing, look, I have a home in LA. I'm not interested in anything else, and that actually can affect your entry on a visitor visa if you have a home, because the underlying requirement is that you maintain your ties in your home country. So by buying a home in the U.S., it could actually affect the entry. And again, the home is not an investment, does not qualify as an investment for E2 purposes. So people say, I want to buy a $200,000 home, I'm investing in the U.S. No, it doesn't work. You're just investing in yourself. You're not creating jobs. So a home does not qualify as an investment. And again, we got to watch for those homes and going to putting the kids in school. It's a no.
All right, should we do some questions?
So we're going to open it up to you. We'll start with this gentleman to the right, please. We've got a microphone coming around.
It works.
Okay, looks like it's working. What I understood from the conversation is that there's a timeline for the E2 or L1 visas, like 2 years or 3 years. You have invested money and effort and spent time here. Children are going to school. And one fine morning, the policy changes and you get to a point where the visa may or may not be renewed. So what happens then when the money is invested in a business and you have practically settled down and invested a substantial amount, not just money but time, and then the requirement to relocate if in case this is not extended?
Well, do you want to go, Linda? Go ahead.
Well, I can start on that. The one thing is policies have gotten a little bit more difficult, but the regulations have not changed.
Right.
And so, and people have been winning on appeal with cases where the Immigration Service has been denying them, and then they go to appeal, and then they win on appeal. So again, the process is harder, but it doesn't always mean that you won't get it. And I now, on a more regular basis, when I get somebody a new Office L or a new Office E, they get a very extensive email from me, but I'll set timers every 6 months to check in with them, or every year to check in with them. Where's your business now? Because I want to figure out what alternatives do we have if you're not at the point where you think you can get the extension.
That again is an expensive process, isn't it?
It is.
Of course, because you go through those legal things and you lose focus of your business then.
I've had people, where I said, you need more employees, and they hire more employees, which means they're taking a lot less in profit, but at least they're showing that they've hired employees. And so sometimes, you have to juggle which is the most important factor, and it won't always correspond with good business sense. Sometimes you have to do things for immigration purposes that are not good business sense.
Yep.
Like investing in EB5 project, you're not going to get interest. You have no guarantee that you're going to get your money back, but you do it for immigration purposes. So there's a lot of things we do for immigration that may not make good business sense.
Okay. One thing to add quick is that, plans change sometimes, and it's important, I tell my clients, once you get the visa, you need to check in with me once in a while. If anything changes, check in with me. Maybe you discover a different business opportunity, and that's a possibility. On an E-visa, we have someone who goes to U.S. with one idea, and then they get there and they discover something else. Well, maybe we can get another E2 for the new business. I'm a strong believer that there is always an option. If you talk with your lawyer, if you have a good lawyer and you talk with your lawyer, you'll come up with some option, short-term, long-term. And I feel like we have plenty of visa categories, and as tough it is, we'll find a way. So I'm very optimistic with that.
In such case, isn't the EB5 a better option than the E2?
It's not for everyone, but I'll let John.
The problem with EB-5 is that how
Takes
long
too
does it
long.
take to get the benefit? Okay, filing the I-526 right now, the minimum amount of time, which is the immigrant petition, is taking 14 to 18 months.
24,
and so if
26.
or longer, and so that's the shortest time. So if you're relying on another non-immigrant status, an E2, when's the last time you came in the country? How long is your I-94 valid for? Or if you're on an L1 where it's limited to the petition date, you're likely going to need to go ahead and extend that. So I think, as we're all saying, is that working with the Qualified Immigration Council, while you may think it's going to cost you a lot of money, I think it costs you a lot more money if you don't.
And last
Okay.
thing.
Can we move
Well, I think we
we
should
need to
move on to
move on
somebody
to
else's question.
Yeah, okay, I'll do.
We've got another question here.
You can share with us later. We'll
Thanks.
commiserate later.
Thank you. Thank you.
As an example, like a student visa is very easy to transition to, like, let's say, work visa. So I think Linda mentioned something about transition. What are the potentials or possibilities of transitioning within these programs? And if so, do you require to leave the United States and come back with a different status? Or can you, like, let's say, going from B1, if you remain in U.S. and then switch to something else?
I can take that.
You
I
can
always,
talk on
I
ease or
prefer the visa.
different.
I prefer a visa, and I prefer going back to the embassy always. If you have the option to change your status in the U.S., you enter with one visa, you get granted that status by the Customs Border Protection, and you can change your status. It is an option, but I always prefer that the applicant comes back, checks in at the embassy, because you told the consular officer that you're going to do something. The consular officer wants you to come back, and it is possible, it is an option to do a change of status, but I'll prefer coming back to the
What
embassy.
about if your family are still with you? I mean, you don't want to leave the school and then come
Right.
back.
There's a certain convenience factor, and I mean, I get that. And I think that Ruslan's point in many, many cases makes a lot of sense. If you came in as a student, you switched to optional practical training, and let's say you were fortunate enough to get selected for an H-1B visa, well, I think in H-1B it would make sense staying in the United States, because number one is not sure whether or not you're going to get it. And
You
so
get cap protection.
Exactly. There's certain protections that come with that. But I would say that if you came in the United States as a student, did not get selected for an H-1B visa, I think my personal preference would be considering going to your home country, maybe then applying for an E-2 and coming back, because the student visa, like the visitor visa, requires purely non-immigrant intent. And if you were to overstay your status here, then it's implied that you want to immigrate to the United States. Then it could create a problem for you applying for any future visas. So it's kind of a weighing process, a balancing of trying to figure out what is your best strategy. Yeah.
One thing people should understand is that the U.S., when you come into the United States or you go to the embassy to apply for a visa, they presume you have immigrant intent.
Yeah.
They presume that you want to stay in the United States forever, that you're not going to leave. And it's your burden to prove to them that you intend to return home after being a student or after getting a visitor's visa. And you have to show ties to your home country, a job, property, whatever it is, to show that you're going to go back. And so that's the presumption of our immigration system, is that you intend to immigrate here. And you have to overcome that if you're going to get a non-immigrant visa that requires non-immigrant intent, like the B1, B2, or even the E2. The L1 visa does not require non-immigrant intent, so you can come and intend to immigrate, and they're okay with that. So these are the things the lawyers will help assess with you as to what visa is available. For an E2, you will rarely do an extension. You will always go back to the U.S. Embassy. For an L1, we'll probably do extensions in the United States.
Yeah.
Time for one more question, and then I know the panelists will stay here for additional questions. I'll take this gentleman right here. We've got a microphone.
Just yell out your
can yell
question.
it.
We'll hear it.
We'll repeat it.
Yeah, I would like to understand if somebody who have been applied for like a visitor visa in the past, denied for 2 times, for example.
Oh.
If now you want to apply for the like a business visa, how's the process is changing or is the same?
I have one specific example where I recommended a visitor visa. They filled out the application themselves. They got denied, but they went in and said, look, I'm planning on doing business in the U.S. I want to get an E2 eventually. They got denied the visitor visa. They went back and they said, look, I told you I'm going to apply for request an E2, and they got the E2 visa. It's not a black and white. It's because you have it depends what you have those denials for. A lot of times it's a credibility issue. Maybe during the visitor visa, the officer didn't have faith that you're coming back, or maybe you're going to do something else. So in that particular case, worked out fine. So I would say a denial is not necessarily talking with a good immigration lawyer would make a difference in that case, I would say. But I would say you have a decent chance of getting a visa. I'm not sure what you're experiencing.
Yeah, you can overcome it if you set up things correctly to then demonstrate. But there are some countries that there's an inherent bias that they no matter what you do, they don't believe that you're going to go back. And it's the rate of issuance of visitors' visas are very low. And so again, to show that you're going to set up a U.S. company, show that you have contacts, show that you have ties, you have your home, your family, your business is in whatever country you're coming from. You have to show that you're going to return. And as I said before, the burden is on you to show that. And so sometimes we say, take some time, build up those ties so that you're more credible when you go back to the embassy the next time. The L1 doesn't, or the H1 doesn't require non-immigrant intent. So you could be denied a B1, B2 visa 5 times. You go for an H1, you're going to get it because they don't care if you're going home or not. So it just depends.
Strategy.
Okay.
Right.
If you could join me in thanking our panelists today with a warm applause. And I know, as I mentioned, they will stick around and answer additional questions that you have one-on-one. So thank you very much.